Test was negative. Mr. Ibarbo, you wanted to say something, sir?
You could address the court.
Yes, sir. I'm just, y'all are swapping alcohol drug out my whole life. I went through treatment. I reached a point when this case came about, everything, my whole life, the futility of it all was overwhelming. And anyway, so I've been cleaning souls since July the 8th. I go to AA regularly. I like it. It's where I belong. I've got a sponsor today. I'm walking the steps. I'm just on step 4. It was where I found a purpose that I've never had. And I think I could do well on probation. And hopefully one day save somebody else from living another day, what I've lived. Which is horrible addiction. Now that's all about it.
Thank you, sir. Mr. Coleman?
Judge, I'll be brief. I think the PSI speaks for itself as far as criminal history. I would like to add, I have judgments here. I've made them available to Mr. Kimler for additional convictions that were either not included in the PSI or they could not confirm those. And for the record, Judge, I am speaking of a 2013 aggravated assault out of St. Charles, Louisiana, in which the defendant received a 6-month probation. Also, a 2008 possession of a controlled substance case out of Kansas, in which the defendant was revoked to 20 months. In a 2013 fleeing or attempting to elude out of Kansas, for which the defendant received 5 days. I think that one is actually reflected in the PSI.
Okay.
The 5-day one.
Yes.
Also, Judge, I have judgments out of Spokane, Washington, for 1, 2, 3 thefts. One from 2011, 2 of them, it looks like it was a concurrent 1-year probation in 2008, and also a 2008 assault out of Spokane, Washington, in which the defendant received 338 days. And I've marked them. I'm happy to offer them.
No objection.
I don't know that I need them. I've made the notes and we'll take that into consideration as
That's all
well.
I have. I think the defendant, given his criminal history, it's a risk of sounding callous, Judge. I get it. People are struggle with drug addiction all the time. But at a certain point, Judge, there comes a point where the consideration needs to be protecting the public. This defendant's been having contact with law enforcement since 1988. And he has spanned at least 3 different states with his criminal behavior. Judge, he's fortunate to have a capital 10. He's exposed to 20 years, Judge.
This right here is the prosecution stacking the deck. Notice how they methodically list convictions across multiple states. That's not just dramatic, it's strategic. They're building a narrative of pattern behavior, not isolated mistakes. Legally, this matters because prior convictions justify enhancements and harsher sentences. Question for you is this: accountability or punishment piled on punishment?
Asking the court to sentence him to the 2 years.
$4.
I'm guilty of all that. I'm sorry.
Texas, Louisiana,
You're all right.
Kansas, and Washington.
I'm very sorry.
I'm sorry. Arkansas,
6 or 5.
Alabama.
6.
I guess my biggest issue, Mr. Ibarbo, is, well, one of the biggest issues is I appreciate and I'm glad that you have done what you've done over the last few months. I think you probably started off doing that for the wrong reason, and that's because you got caught again and you're looking at 20 years in prison. It sounds like maybe you're doing better, and that's great. I just wonder why it's taken so long. It looks like you went to the Unity House back in 1986, and other than that, it's just, at some point, you've got to take responsibility before you commit an offense, not after. I've counted 24 misdemeanors. I think with some of the ones that Mr. Coleman has said, there's probably actually more than that. There were some records that couldn't be found from different states. They're probably looking at more like 30. 7 felony convictions. You've been to prison. It's just too much. And at some point, there has to be an end to what you're doing and get that help before you continue what you're doing. I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. In cause number 24, DCCR 1722, find sufficient evidence to find you guilty, and at this time find you guilty of theft, find your prior enhancement convictions true, sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody.
And let's break this down because this is huge. Concurrent sentences mean he serves both 7-year terms at the same time, not back to back. So instead of 14 years, he's looking at 7. This is the judge balancing consequences with restraint. It's not leniency, but it is mercy within the law. Do you think this sentence strikes the right balance, or should the court have gone harder?
That the law gives you the right to receive. Clause number 24, DCCR 2289, also find sufficient evidence to find you guilty, and at this time find you guilty of theft and find those prior enhancements true. Sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These will run concurrently, which means together at the same time. I've handed you the trial court certification in each of those cases that shows that these were agreements that I've followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. Good luck to you, sir.
Yeah, that's good.
Thank you. Thank you, Mr. Kimler and Mr. Coleman. Thank you.